And this has come through one judgment, which we'll talk about as we go on. I hope I can do this, but if I don't go full screen, I will show you only the other way round. This is how I'm going to go. I'll first talk about the MTP Act 2021 and the Honorable Supreme Court judgment regarding this. Then I will introduce the topic of maintaining the privacy and honoring the privacy of a sexual assault survivor. I'll be talking about one landmark case that occurred before 1983, which led to one of the major changes in the laws related to sexual assault. Then I'll talk about the law of the land, views of the Honorable Supreme Court of India, and how we handle sexual assault cases in GMCH. Now, the MTP Act. I'm going to tell you about the major things in MTP Act. The first thing you should know in MTP Act is that the 2021 Act, it raises the period of gestation from 20 to 24 weeks only for certain number of cases, not for all cases. If there is failure of contraceptive devices or methods, both for married or unmarried women, the maximum gestation period is only 20 weeks, by up to which you can get an MTP done. From 20 to 24 weeks, there are certain categories of women as specified in Rule 3B(c) of the Rule 3B of the MTP Rules 2021. And beyond 20 weeks, only for fetal anomalies, and that is to be decided by a standing board that is constituted by the state governments. Now, as per Rule 3B(c), there are seven categories of women, which I hope you know. The survivors of sexual assault, that is rape or incest, minors, change of marital status during pregnancy, that is, if a married woman has either been divorced or has become a widow. Then women with major physical disabilities, as explained under the Disability Act of 2016, mentally ill women, including mental retardation, fetal malformations, and women with pregnancy in humanitarian settings, like in disasters or emergency situations. The judgment of the Honorable Supreme Court in Miss X versus Principal Secretary Health, Government of NCT of Delhi, deals with only one part of these categories, and that part it deals with is the change of marital status during pregnancy, widow or divorced. Now, before we go to that, who can terminate pregnancy? Up till 9 weeks, this is as per the rules, up till 9 weeks, any RMP with 3 months of experience in gynae obs, or one who has performed 10 MTPs under direct supervision in a government hospital. If the gestation period is up to 9 weeks, then only one RMP can do this if he has this experience, and this is to be done by medical methods. Now, 9 to 12 weeks of gestation period, it is a person who has done 6 months of house job in any gynae obs department. 12 to 20 weeks, a person with 1 to 3 years experience or an MD or a diploma holder, only one doctor can decide and perform. 20 to 24 weeks, again, 2 doctors with the experience as for 12 to 20 weeks. This is what is the qualifications that are required for a doctor who can perform MTP in various gestation periods. Now, this is the main one. There were 2 judgments by the Honorable Supreme Court. Now, I'll tell you who is Miss X. Miss X is a resident of Manipur. She was staying in Delhi. She was in a living relationship with her partner, and she was 22 weeks pregnant when she applied to the Delhi High Court for termination of pregnancy, because she said that there has been a change in her status, that is her partner with whom she was having a living relationship, he had deserted her.
No,
She has.
slide not moving, sir.
Anji?
Slide not moving, sir.
I have not changed the slide.
Okay.
I have not changed this slide. I will change this slide later on. I am just telling you the history of that case. So she said that there has been a change of status because now she has been deserted by her partner. But Delhi High Court said that she does not fall under any section or any category as per Rule 3B, and therefore it rejected her case. Then she applied to the Supreme Court, and Supreme Court then gave this judgment. There are two judgments. You can go through them. One was given in July 2022, and the other has been given in September 2022. In July 2022, it gave an interim judgment, and in that judgment, it directed the director of AIIMS New Delhi to constitute a board, and if this board is of the opinion that the pregnancy can be terminated without any harm to the lady, then it should be terminated. So the director constituted a board, and her pregnancy was terminated before the pregnancy came up to 24 weeks. Later on in September 22, it gave the major judgment. There are number of landmark things in that judgment. You have to read it to understand it. In this judgment, the court said that differentiating between a married woman and an unmarried woman for change in status is wrong, and therefore it said that change in status should also include women who have been separated or deserted or abandoned by their partners. So both married women as well as unmarried women have been made eligible for medical termination of pregnancy up to 24 weeks under Rule 3B C, clause number C, where there is change in the status of the relationship. Previously, it was only for married women, that is, either she becomes divorced or deserted or widowed. Now it includes unmarried women too who have been separated, deserted, or abandoned by their partner. This is the landmark judgment given by the Honorable Supreme Court. This Honorable Supreme Court does not say anything about failure of contraception, which, as I told you previously, is only up to 20 weeks. And fetal anomalies is for a period more than 24 weeks, but that has to be done by a board constituted by the state. And there is no gestation period, limit of gestation period if there is a fetal anomalies. Again, this judgment is very important because it, for the sole purpose of MTP, it recognizes the concept of marital rape. If a married woman has been raped by her husband and is forced to carry on with an unwanted pregnancy, then she can go in for termination of pregnancy. So marital rape as a concept has been recognized for the first time in our country, but only for the sole purposes of MTP. Second, it also tells us how to give information for those minors who come for the purposes of MTP with consensual relationship, not those who have been sexually assaulted. If a girl, minor girl, due to consensual sexual relationship becomes pregnant and she wants to terminate her pregnancy, as per section 19 of the POCSO Act, because she is a minor, you are duty bound to inform her. But here, the Honorable Supreme Court says that when you are informing the police, you need not give any details of the girl. You just have to tell the police that today a case has come to us regarding MTP, and this was a case of a minor, so it falls under POCSO. Who the girl is, what is her address, who are her parents, you have nothing to do with that. It is the police duty to tell. This is what the Honorable Supreme Court has said, and this has been very nicely explained in the judgment. Please go through that. So this is the act and the judgment of the Honorable Supreme Court. Now, we will talk about why we need to preserve and maintain the confidentiality and privacy of a sexual assault survivor. We all know that the cases of sexual assault are keeping on increasing. This may be because of improved
अरे सर
reporting.
आपकी स्लाइड
हाँ जी,
स्लाइड चेंज नहीं हो रही है सर, स्लाइड चेंज नहीं हो रही है.
मैंने तो चेंज किया बस. I have
नहीं,
changed
स्लाइड
it.
इज ओनली.
मेरे इसमें चेंज हो रही है. Okay, let me go like this. Is this
हाँ सर,
okay? Now
Is
this
this
is
okay?
this is seeing now.
हाँ, दिस इज चेंज.
Okay,
Yeah, visible.
we'll go like this. Okay, so this can be because of improved reporting or better awareness among the victims. And now number of states, they are giving compensation for minors under POCSO. I think a minor gets around 3 lakhs of rupees as compensation if she has been sexually assaulted. Another important thing is that in cases of sexual assault.
Sir, sorry, sir. Sorry to interrupt you, sir. My one question is there, sir.
You can do that in the later, I suppose.
Okay, sir. Okay, sir. Okay. Thank
You can, Dr.
Okay, sir.
Sanjay will moderate this.
Yeah.
And later on he will
Right.
do
Okay,
this.
sir. Okay. Okay, sir. Okay.
Okay. So in the sexual assault cases nowadays, minors and pediatric age, that is minors, are increasing. One small example is in my own UT, that is Chandigarh. 75% of the rape victims are minors, and this is as per the census of 2020. So that is the higher proportion of minors in cases of sexual assault. Now, because of the tender age of the victims, it makes them more vulnerable to suffer risks of continued onslaught. And it has also been seen that male children are also becoming increasingly the victims of sexual assault. It is not only the females, it is also the male children who are becoming victims of sexual assault. And therefore, as per the Honorable Supreme Court of India, it calls for all concerned to show greater sensitivity towards the issues related to revealing the identity of survivors of sexual assault. Now, we know that it is an offense to reveal the identity of a victim of sexual assault, particularly rape in our country. It is mandatory to protect and respect the privacy and confidentiality of the victims of these offenses. In Nipun Saxena and another versus Union of India, the Honorable Supreme Court has said that the victims of sexual offenses, particularly of rape, are treated worse than the perpetrators of the crime. They are ostracized by their own society, treated as untouchables, and even her family thinks that there has been a loss of family honor, and they put the entire blame on the girl herself. Again, the Honorable Supreme Court says that in the police stations and even in the courts, they do not give much dignity and respect or sympathy to the female survivors, which they should be given. But these survivors are made to feel as though they are the main cause of the crime and the whole incident is their fault. So the court says a minor who is subjected to sexual assaults need to be more protected than an adult victim, because the adult victim may be able to withstand the onslaught and the mental harassment, but a minor victim will not be able to do so. And therefore, the court says that in number of times, the perpetrator of the sexual offense in case of minors may be the one of the family members itself. And therefore, the whole family wants to hush up the case so that the family honor does not go out. Therefore, attempts should be made by everyone who is concerned to maintain the confidentiality and privacy of a child, and this should be mandatorily respected and protected by all people dealing with such cases. This is what the Honorable Supreme Court says. Now, there have been two landmark cases, and both these landmark cases have brought in changes in the laws related to sexual offense. The first landmark case was way back in 1983, which we all know as the Mathura rape case. Mathura was a minor girl who was raped by two police constables, Tukaram and Ganpat, in Desaiganj police station in Maharashtra. She filed a case, and there the Sessions Court, it said that the police constables are not liable as this was a sort of consensual sexual intercourse because of two things. One, Mathura did not have any injuries on her body. Two, she did not raise any alarm. And three, she was habituated to sexual intercourse. These are the three statements made by the Honorable High Court at that time, Sessions Court at that time. However, High Court, it overturned this judgment, and it gave Ganpat and Tukaram 1 and 5 years of imprisonment, respectively. Again, this judgment of the Supreme Court, of the High Court, was overturned by the Supreme Court. And Supreme Court again said the same thing. Mathura has raised no alarm. There were no visible marks on her body. So she was, did not struggle, and therefore there was no rape. And this was a consensual sexual intercourse. Court also said that because she was used to sex, she might have herself incited the cops who were drunk on duty to have intercourse with her. And the Supreme Court allowed these two people, acquitted these two constables. This led to a lot of outrage and protest by various women's organizations, legal luminaries, etc., all over the country, and forced the government to bring radical changes in the law related to sexual offences through the Criminal Law Amendment Act 1983. Now we all know the genesis of the Criminal Law Amendment Act 2012. The Nirbhaya rape case, we all know, that led to the second major landmark changes in the laws related to sexual offense. So both the changes have occurred because of the outrage by the public over the sexual offenses meted out. Now, what are the laws now? The most important law is section 228A of IPC, which says identity of an alleged victim of offences under section 376, 376A to E cannot be printed or published or made public or revealed. So, for any sexual assault survivor, you cannot reveal her identity in any form. Identity can only be revealed by or under order of an SHO or by authorization of the victim herself in writing. And if the victim is dead or of unsound mind or is a minor, on the written authorization from the next of kin. The court also says that the Act also says that no such authorization shall be given by next of kin to anybody other than chairman or secretary of any organization of the state. If you remember Nirbhaya's case, the parents of Nirbhaya, particularly the father of Nirbhaya, wanted her name to be publicized because he wanted her to become a martyr. But the courts did not allow, and we only know her as Nirbhaya, but we do not know her real name. Now, this is regarding adults. Regarding minor children, we have two acts. The Protection of Children from Sexual Offences Act, that is POCSO 2012, and the Juvenile Justice, that is Care and Protection Act 2015. These are the two acts that are related to minors. Now, in POCSO, it is mandatory that the right to privacy and confidentiality of a child survivor be protected and respected by every person by all means through all stages of a judicial process involving the child. Nowadays, if you see, like the last judgment by the Honorable Court, it does not give the name. It only says Miss X. The Supreme Court has now decreed that even police officers in their FIRs, in their challans, which every public person, which public people might be able to read, the name of the survivor, her address, nothing will be revealed. She will only be either X or Y or Z. Even in judgments by the various courts, you cannot reveal the name. This has now become so stringent. And in POCSO, the Act says that law should operate in such a manner that the best interest and well-being of a child should be given paramount importance. Section 23(2) of the POCSO Act prohibits disclosure of identity of a child or survivor. You cannot disclose her name, address, photograph, family details, school or neighborhood, or any other particulars that will lead to the disclosure of identity. So nothing can be given. In our hospital, we only say Miss X, resident of Chandigarh, Miss X, resident of Punjab, Miss X, resident of Haryana, nothing else. Section 24(5) requires police officials to ensure that the child identity of the child is protected from media unless directed by a special court. Section 33(7) of the POCSO Act again says the special court shall ensure that the identity of the child is not disclosed at any time during the course of investigation or trial. So you see that throughout, right from the police, doctors, court, nowhere can the child's identity be revealed. This is what the Act says. Now, POCSO rules also say that whenever a child who is a sexual assault survivor is brought to the hospital requiring emergency medical care, then that emergency medical care shall be rendered in such a manner as to protect the privacy of the child. And the hospital shall not demand any legal document as a prerequisite to providing medical care. So again, no documents can be required, can be asked. Again, all forensic evidence that are to be collected should be collected in accordance with Section 27, and the report should be submitted within 24 hours to Special Juvenile Police Unit or to the local police. This is as regards the protection and maintaining the privacy of a child as per the POCSO. Now let's see what Juvenile Justice Act says. Section 74 of the JJ Act, it prohibits disclosure of identity of a child. It states that no report in any newspaper, magazine, audiovisual media, or other forms of communication should be there regarding any inquiry, investigation, or judicial procedure. Nothing shall disclose the name, address, school, or any information leading to the identification of child in conflict with law. This is now not sexual survivor. It is a juvenile who is in conflict with law. Even his identity or her identity cannot be revealed. And this is what Section 74 of the JJ Act 2015 says. Now, what is the most important mandate of these legal provisions? that none of these provisions regarding revealing the identity of a child can be waived either by the child or the parent of the child. So they themselves, because the child is a minor, he doesn't have this right to reveal her identity or his identity, and the parents have not been given. If you have seen the POXO Act, it says that it can only be given to special government organizations, not to anyone else. So you cannot reveal the identity of a child, either who is a sexual sexual assault survivor, or if that child is a child in conflict with the law. Now, what does the Honorable Supreme Court state? The most important judgment regarding this is this judgment, Nipun Saxena and another versus Union of India and others. This is the most important judgment. This came in somewhere in 2018. And you can look into this. Now, this says, it clarifies regarding section 28A of IPC. It says, obviously, not only publication of name of victim has been prohibited by the Act, but also disclosure of any other matter which may make known the identity of such a victim. So not only publication of the name, but anything which may reveal the identity of the child or the victim can be revealed. You cannot reveal anything. Everything has been mandatorily prohibited. Identity of the victim should not be known from any matter published in the media. Now, let's talk about the Supreme Court again. It says that police officers who are investigating such cases should use pseudonyms to describe the victim, unless absolutely necessary. So, the challan part by the police, no name or identity can be revealed. It is a pseudonym. Only a sessions judge or a magistrate can give the order that a copy of FIR be given to certain people, giving reasons for the same, keeping in view the interest of the victim. So the FIRs in these cases are not public documents. They cannot be given to anyone who is requesting it, can only be given to some special concerned government officials. And they have to ensure that they will not reveal the name, or the FIR in their custody will not go public. Now, where can you where can we reveal the identity of the victim? When you have to take samples from her body, when you have to do medical examination, when you have to do DNA profiling, when date of birth has to be established from school records. These are the 4 instances given by the Honorable Court. But the court says, even in these circumstances, police officers to use caution and disclose as little of identity of the victim as possible, but enough to link the victim with the information sought. So even in these cases, the identity of the victim can only be revealed to concerned officials and to no one else. Again, it says the authorities to whom the name or identity of the victim has been disclosed are duty bound to keep it confidential. And they cannot disclose it in any manner except in a report which should only be sent in a sealed cover to the investigating agency. And any document that can be scrutinized by a large number of people should have only pseudonyms. It cannot have the name or identity or the photograph or any address of the victim. Now, the government here, the Honorable Supreme Court says that if a adult victim has no objection to her name being published or identity being disclosed, then she can authorize any person in writing to disclose her name. This is very important, that if there is an adult female and she wants her name to be disclosed, she will have to authorize people in writing. And this is a conscious and voluntary act of the victim. because the court says that some victims may be so mentally strong that they are willing to face the society even after name has been disclosed, and by doing so they can help other victims of rape and become a source of inspiration so that other victims come forward and complain to the police regarding the sexual assault that they have faced, so they can act as a beacon of light for other victims. And for that, those adult victims who are strong enough can authorize their names to be published. Again, if a dead body of unknown victim is found and it is established that she was subjected to rape and that it is not possible to identify her, then her photo, without publishing her photographs in newspapers, then the fact that she has been sexually assaulted should not be made public in those photographs. You just publish a photograph saying that such and such victim has been found, and if anybody recognizes her, you come and you identify her. The fact that this victim has faced sexual assault should not be revealed in those photographs. Whenever identity of a victim needs to be revealed, an application is to be made to the sessions judge or special magistrate, who may authorize, but with giving reasons and keeping the mind and keeping in mind the welfare of the victim, he can authorize her name to be revealed. Even dead have dignity which cannot be denied to them. This is what the Honorable Supreme Court says. So, how do we handle such cases in our institute? The first and the most important case which came to us was a 10.5-year-old girl. This girl came to us, our institute, in 2017. She was a child who had been repeatedly, around 10.5 years, who was repeatedly raped by her maternal uncle. And when she came to us, she was around 28 to 30 weeks pregnant. And the girl did not know. She only felt some pain in the abdomen. The mother did not know because the girl was slightly well built, and therefore the bulge in the abdomen was not properly noticed. It was only when some other woman in the society told her, told the mother that your child's abdominal girth is increasing, did she get suspicious, and then the girl was first taken to the our government multi-specialty hospital at Sector 16, and from there she was referred to us on in July 2017 for checkup and for other processes. When she came to our hospital, a board was constituted, and I was made the chairperson of the board, and we were asked to opine on two major things. One is the duration of pregnancy and whether termination of pregnancy will involve risk to the life of the child or cause a serious injury to the mental or physical health of the child. These are the two questions asked of us by the court, the Sessions Court of Chandigarh. Now, one thing in Chandigarh, Punjab and Haryana is that a male doctor cannot examine a female patient. And as this girl comes under POXO, we all know that in POXO, as per POXO, only a female doctor can examine a girl child who is a victim of sexual assault. So the board had a number of lady doctors who are from the Department of Gynae Ops. I was the chairperson to look after the legal implications and the medical legal work. So the girl was examined, the child was examined, and we found her to be 30 plus minus 2 weeks pregnant with a viable fetus of 1.4 kg. It was a normal pregnancy, and we told the court that the pregnancy needs to be continued till term, as termination is not in the interest of either the child or of the fetus, because she was already 30 plus minus 2 weeks. Now, this case went to the Honorable Supreme Court because a PIL was filed in the Supreme Court. This was the CWP 565 of 2017, and it was filed as Alok Srivastava versus Union of India. And through this PIL, the Honorable Supreme Court started monitoring the progress of the child in GMCH. And we, the board, was mandated to send regular status reports through the state legal agency to the Honorable Supreme Court. And then the Supreme Court, it clubbed this CWP, that is Alok Srivastava versus Union of India, along with its other case, Nipun Saxena versus Union of India. And it ordered us that the identity of the victim, newborn baby, parents of the victim, workplace, residents of parents, nothing is to be disclosed. Identity of the victim, identity of the newborn baby, parents of the victim, workplace, residents, etc. cannot be disclosed. Otherwise, it said that you will face prosecution under section 228A of IPC as well as contempt of the Honorable Supreme Court. It also said that all medical records of the victim and the newborn baby should be kept in sealed covers with hospital authorities at discharge. And because you are mandated to give a copy of the report to the victim, it said you will give the discharge report to the victim under the name X to her parents. No, nothing to be written anywhere regarding the identity of the child. And if any counseling of the child needs to be done, it will be done by the hospital under home visit only. The child will not come back to the hospital again. So, in compliance of the orders of the Honorable Supreme Court, what we did as a board, what we made SOPs for this, and what we did was we changed the name of the girl as X, daughter of Mr. A, in the discharge summary. And the name of the baby was changed as baby of X, care of Child Welfare Committee, UT Chandigarh. Now, why did we not name it care of Mr. A? Was that the father of the girl child, he said that I don't even want to see the face of the baby. I have nothing to do with the baby, and he refused to take care of the baby. So we called in Child Welfare Committee UT Chandigarh, and they took the custody of the child. So the girl child was given as Miss X, and the newborn baby was named Baby of X, care of Child Welfare Committee UT Chandigarh. The birth certificate of the baby will also bear the same name as Baby of X. This was what we opined and what we directed the hospital to do. Then we also said that now we had a case file with her name. Okay, so we had to now erase her identity. So what we did was we said that the medical records department will freeze the present CR number, that is her number, UID, and issue new CR number to the mother and baby, and then link the both medical records. That means presently you have the record with a particular name and address of the child. This will be freezed and the record will be sealed. And another record will be made in the name of Miss X, and both these records will be electronically combined. So that if you open Miss X, then you can get the details of the case. But this authority will only be with the concerned doctor who is treating the child and nobody else. So that is how we did. We also said that the whole record of the child and her baby would be sealed and handed over to the MRD after the child was discharged. Again, The girl child had been treated. She was kept in the hospital for 2 weeks. She underwent normal delivery after induction. So she stayed in the hospital for around 14 to 15 days. All her investigations were made in form of Miss X. We said that as per the Supreme Court orders, all places where her previous number and her identity was there, they have to be struck with permanent black pen, and Miss X should be given with the new CR number, and under it, it should be written as per the orders of Honorable Supreme Court. This is what we did, and we got all the record in the hospital completely erased, and now we only had the name of Miss X for that whole girl. And then we gave we used to present status reports to the Honorable Supreme Court. And if you read the judgment of the Honorable Supreme Court, you can see that the Supreme Court did mention about GMCS 32 and said that the doctors there had done good work regarding this. Now, what is the present procedure? In order to prevent the disclosure of identity of the sexual assault survivors, both minors and adults, we prepared SOPs, and these SOPs are being followed right from the time the sexual assault survivor enters the hospital. Now, please understand this procedure. As soon as the victim comes to the hospital, either on her own or under court orders or through police, the emergency medical officer in the casualty will make an observation file either in the name of X or Y or Z without noting any other details which can potentially reveal the identity. If that victim is from Chandigarh, he will say Miss X, residence of Chandigarh. If it is from Punjab, Miss X, residence of Punjab. Nothing else will be asked from the girl. Only this will be asked. Then the survivor will be sent to our own one-stop crisis center, OSCC, with an attendant. And here at our one-stop center, all her treatment, medical legal examination, relevant investigations, counseling, etc., will be done by the doctor of duty, as well as any other doctor who is in need at that time. That means, suppose the doctor on duty from the Department of Gynae Ops wants a surgeon, the surgeon will be there. If it wants a psychiatrist or a orthopedician or any investigations, radiology department, all will come to the OSCC and do the examination or investigations there. The girl child or the woman or the victim of sexual assault who comes to the OSCC will not leave the OSCC till her complete medical legal examination is done and report prepared. And this is how she is examined. Now she has come. We have registered her as Miss X, and the EMO has not asked her anything else. Now, once she enters the OSCC, the doctor, usually senior residents from the Department of Gynae Ops in our hospital, they are the ones who do the medical legal examination and prepare the reports. The senior resident on duty who is examining this girl, who will be examining this girl, will take the identity proof there. Either the identity proof can be an Aadhaar card or a voter card or anything of the survivor. And if the survivor is a minor, then one of her parents. Okay, so one identity proof is taken. This will be verified with the original, giving, and then the senior resident will sign on the identity proof that she has taken, that she has compared it with the original, giving date and time and her signature and her complete name in block letters. This is what is to be done. Then this identity proof is sent to the office of the Gynae Ops giving the MRD number. We call our medical records department as MRD, and therefore the number that is generated by the MRD department, we call it as our MRD number, or you can also call it as an UID, Universal Identification Number. So the number is given. Now, CR number or MRD number, date and time of registration, pseudonym used at the time of registration, along with your signature. All these will be written on the top of the envelope, and it will be sent to the Department of Gynae Ops. The Gynae Ops department will maintain a register of the same, and this register will be there, the file, where this will be entered, and it will be given a serial number. This serial number will also be given onto the envelope, and the envelope which is sealed is stored there. Now, we all know that senior residents, junior residents, they have a tenure job of 3 years with us, so they leave. So we have also asked the department, because we do in our department signature and a photograph register. Every doctor who comes, who joins our department, will have his full signature, his small signature, as well as his photograph, his complete postal address, his phone number in our register, so that when he leaves and we go to the court, we are able to show to the court that, see, this is the signature. Court asks you to identify the signature, so we show this. So we have this, maintain this photograph and signature register for all our doctors, whether they are faculty members, whether they are residents, or whether they are demonstrators. So we have requested the Department of Gynae Ops also to maintain this. The safe custody of this document will be the responsibility of the doctor and the department. And if the survivor needs admission, file will also be made in the same pseudonym. Throughout the hospital stay, the file will be in the custody of the senior nursing officer of the ward, and it will be given to the doctor for putting notes, prescribing treatment, etc. during rounds. After that, again, it will go into the custody of the nursing officer. All investigations will be requested using this pseudonym and CR number. No department in the hospital will ask for any other details of such patient. Now, in all cases where you need an ultrasound, you have to, as per the PCPNDT Act, you have to inform the authorities. We send the information in sealed cover to the authorities. No department will preserve any information which has potential to be used in any way that may lead to the identification of the patient. Even on discharge slip, no identifying data will be mentioned by us. Now, sometimes patient gets admitted with a vague history and later on narrate story of sexual assault. So when she comes with a vague history, already her name is there. Now, when she gives history of sexual assault, what we do is, we, just like we did it in the 10.5-year-old girl, we freeze this previous one and issue a new one in the name of Miss X or Y or Z. And this previous one where her name is, that will be sent in a sealed cover to the department, to the MRD. And the new one, new CR number will be linked with the old CR number. So if for all record purposes, we will again have Miss X or Miss Y and not the real name. Again, all departments where investigations were already sent will replace the name with the pseudonym, giving the date and time when this change has been made. The rest of the procedure is the same as is being followed for a new admission. Now, what happened recently was, a minor girl, 17 years, came to our pulmonary medicine department. She had come with her child. She was 7. She gave her age as 17. She came with her husband, and she was with a child, 1-year-old child. Now, this case, which had come to our pulmonary medicine OPD, becomes a POXO case. This came only recently, so we gave information to the police as per the directions of the Supreme Court in Miss X versus Principal Secretary Health and City of Delhi. That means we told the police that one case has of POXO has come to the hospital, and this girl is a resident of Chandigarh. That's all. We did inform the police, but we did not reveal her identity. And she was treated for the ailment that she came, and she was allowed to go home by us. Now it is up to the police, because we did as per the orders of the Honorable Supreme Court in Miss X versus so and so. So this is how we did dealt with that case. Now minor male survivors, the only difference in minor male survivors is that instead of the examination being done by the Department of Gynae Ops, the examination here will be done by EMO. The EMO will take all the details and send the same in a sealed cover to our department, that is Department of Forensic Medicine and Toxicology. We have found this protocol that we are following in our institute to be one of the best possible for almost all situations dealing with victims of assault. And this is in strict adherence to various laws mandated by various judicatures in our country. Now, there are certain guidelines which are there. If you want to follow them, you can. As per the Ministry of Health and Family Welfare guidelines, efforts to be made to find a lady medical officer to conduct examination of a woman survivor. We are talking about adult woman survivor. If an LMO is not available, then can be done by a medical doctor in presence of a female attendant. This is for adults. For minors, you know that only a lady medical officer can examine the child. As per Section 27 of the POXO Act, during examination of a child, a parent or any person in whom the child trusts is to be present at the time of examination. And if such persons are not available, trustworthy. And finally, Section 357 says that it is compulsory for hospital or doctor to provide treatment to all survivors of sexual violence. We know that Supreme Court of India in Ashwini Saxena versus State of Madhya Pradesh has said that it is not necessary to do age estimation of survivor in each and every case. Age estimation is only required in those cases where you are in doubt and when you do not have reliable documentary proof of age. And never should you document past sexual practices or history during medical legal examination of survivors or victims of sexual violence. Now, I have certain references, and thank you. I think I have already taken more than 55 minutes. Thank you all for a patient hearing, and I now finish. Now, Dr. Sanjay Gupta, please.
Thank you, sir, for this wonderful talk. You have covered the most of aspect and shared the practical experience with all of us. I'm sure that the participants who are attending these sessions must get benefit from your talk and your experience. So if there are specific questions, because I don't see any question in the chat box, so you can unmute yourself and please ask. There is one question in the chat box that, sir, I'm reading this question.
Yeah, please.
The benefit of everyone. The question is that many a time police bring female below 18 years of age with history of ran away with her boyfriend. Case is being under 363. Now they request kindly comment either they had sexual intercourse or not to be booked under section 376. How to proceed?
If the girl is less than 18 years, then section 376 will not apply because it comes under POXO. And if it is under POXO, then it is to be examined, then the girl is to be examined only by a lady medical officer. And then the lady medical officer will do the normal examination that is routinely done, take the samples, take proper history, And after taking proper history, doing the examination and samples, and when the reports of those samples come, then we can opine. Before that, how can we opine anything? I don't think we can opine anything before doing a complete medical legal examination, taking complete history, taking all the relevant samples, sending them for investigation, and only when the reports come can we opine. I don't think that I do not know, some of the institutes, they want interim reports. I do not understand the concept of an interim report. What if your interim report has to be changed after you get the reports from the investigating officers from the various labs that you have sent? So please desist from giving interim reports. You give this and say that final opinion regarding this case will be given after the results of all investigations have reached the undersigned. So this is my take, that you do a complete, you take a complete history, do a complete medical legal examination, take all relevant samples, send them to the various labs, and once the reports come, then you can opine.
Sir, his next question is that if the
Sir,
minor,
my question is,
Yeah, please.
yeah,
hello.
Anji.
My question
yeah.
is, sir, if a POXO female victim comes for the examination and she is pregnant
What is her age?
and she want below 18, sir, below
Below
18,
18. Okay.
POXO, under POXO, Act,
Okay.
below 18, and she doesn't want to terminate her pregnancy, and parents want to terminate the pregnancy, terminate her pregnancy.
And she wants to carry on with the child.
So what should be the yes, yes, yes.
So let me
Two
tell you your
situations are
question.
there.
Yeah, your question is that this girl is less than 18. She is pregnant. She wants to keep the
Uh,
child. The parents want the pregnancy to be terminated, right?
yes, sir. Yes, sir. And next question is, if
Okay,
both are willing to
Dr. Pramod,
terminate her
Dr. Pramod,
pregnancy,
don't.
sir.
Dr. Pramod, first, let's answer the first question.
The answer for the first question
Okay,
is
sir.
she is a
Okay,
minor. She has no right, because invasive procedure.
okay, sir. Next,
This is an invasive procedure, so she is a minor. So only her parents can take the decision. She cannot take the decision.
sir. Okay. In next situation, both are willing for the termination of the pregnancy after informing to the police by a gynec doctor. Okay, Miss X came for the this is under POXO Act. Now the products of conception, for how many days it is to be kept, and the victim and her parents doesn't want or doesn't willing for the complaint.
Okay, now let me tell you this.
Yes, sir.
This is explained by the Honorable Supreme Court in
Mhm.
the judgment that I had told you. There is a separate 3 or 4 paragraph regarding MTP and POXO Act. Please go through that. In that, you have to only give information that one minor girl came for MTP. That's it.
Okay.
You do not have to tell her
No,
name or identity or anything. Since you do not have to tell her
yes,
name
sir.
or identity or anything, where does this question of preserving the contents of this one components come?
Products of conception.
Products of
Yes, sir.
consumption, the question does not arise at all.
No, sir. No,
Okay,
sir.
Dr. Pramod,
Initially, in
okay,
our
Dr. Pramod,
institute, sir,
Hmm.
Dr. Pramod, may I
sir.
interrupt you?
One question, please.
Because
In our institute,
there are several questions by the other participants who are listening to the talk
sir,
by the person.
only one
May
question,
I
please. One last
may I
question. One
request you
last
to
question,
please
sir.
ask the question in your national FMT group forum. Sir
Or you
would
can
like
write to
happy
me,
to.
Dr. Sunil. I think
Okay, sir. Okay,
it is
sir.
Dr. Sunil, right?
So sir,
Okay, sir.
next
Yes, sir.
question
Yes,
is
sir.
You can WhatsApp me and I'll WhatsApp you the answers.
Okay, sir. Okay,
okay, sir.
okay,
Next
okay, sir.
question
Hello,
from
Thank you.
Dr.
Thank you, sir.
Benaka.
hello.
Sir, next question from Dr. Benaka. What to do with minor survivor till police comes, especially in reference to the sample collection and MTP in cases of inevitable abortion.
No, I did not get the question. Can you please repeat it?
Sir, she has written on the WhatsApp this chat that what to do with minor survivor till police comes, especially in reference to sample collection and MTP in cases of inevitable abortion. Dr. Benaga, can you clarify? This question seems to be a little bit
Yes, sir.
vague.
Yes, sir. Yes, sir. Good evening, sir. Good evening, sir.
Yes,
Good
Dr.
evening.
Vinaka, what is your question, please?
Actually, sometimes cases come from the periphery, and
Yeah.
police station is more than 100 kilometers far away from the hospital.
Hmm.
And time required for the police IO investigating officer to come to the hospital and take the history, and he record the case, and then he will give requisition regarding the sample collection or the medical examination of the survivor.
No, this
In-
is a case for MTP or this is a case for medical legal examination of a
Sir,
sexual assault minor.
No, in both cases, this is a case of minor, and case may present in the hospital in two forms. One is the sexual assault case, and one is the MTP. She has taken MTP pills in the periphery and then present as an inevitable abortion. So
Okay.
gynae doctors sometimes ask us that she should perform the MTP or not.
No, if she has come for MTP, you have to perform the MTP.
Okay.
And when she has come only for the purposes of MTP, then the doctor has to ask the survivor whether or not she wants her identity to be revealed to the police. Get my point?
Okay. Yes, sir.
When a minor survivor comes with her guardian for MTP purposes only, then you have to ask the minor and the guardian whether they would allow the doctor to reveal her identity to the police. If they agree, the identity can be revealed. If they do not agree, you cannot reveal the identity of the victim.
Okay, sir.
When you cannot reveal the identity of the victim, then there is no necessary to preserve any sample.
Okay. Okay, sir.
It is the police work completely to do the investigation, and if they want any samples, then they will go to the doctor again with the patient.
Okay, sir.
But if she comes
So,
as a case of medical legal examination, then you have to take the samples and then you have to preserve the samples in we usually do it in refrigerators till the police comes. We inform the police and we refrigerate the samples till the police comes. If they do not come, then we write to the senior officers and of our own area, that is Chandigarh only, and they will then talk to their counterparts in the particular area, and we get the things done within here. At least in Chandigarh, it is possible for us to get things done within a week or so at the most.
But sir, we are often advised to preserve the sample as they are the biological sample and will decay with the time.
So you can preserve them, ma'am. You can preserve you preserve them in the freezer section of the refrigerator.
Sir, one more last question. You have elaborated one case of a minor who has visited the pulmonary medicine department.
Yes.
With her child.
Yeah.
Sir, how to hold that minor till the police comes?
Why should you? Who are you? Are you investigating agency?
No, sir.
Then?
But we have not revealed her identity to
Ma'am,
police.
illegal confinement में आपको अंदर कर देंगे इधर ही आपने ऐसे किया तो.
नहीं sir. But
you are not an investigating agency, and Supreme Court says that you cannot reveal the identity. So why should you catch hold of that girl?
No, sir. But मतलब till the police arrives.
Madam, नहीं करना, ma'am, नहीं करना. This is what is wrong. Please read the judgment. Please understand the judgment. And you have my number. You can always talk to me later on when you have read the judgment.
Okay, sir. Okay, sir.
So thank you, Dr. Vinaka. Any other question, specific question to Hari sir? Then we'll take just one or two questions, and we'll close this session. And subsequent questions can be asked in the national FMT group or on the personal WhatsApp number of the sir.
So please take questions from the chat box.
Chat box. Sir, there is a question about, please say something about the mandatory reporting of the survivors, where more than 20% of antenatal mother are below 18 years. This is questions by Dr. Somnath Das.
I would only request that please read the judgment. Everything is clear in the judgment, how to report and how not to report. Those cases, antenatal mothers who are less than 18, how to report to police as mandated by section 19 of POCSO is very clearly written in the judgment. You have to go through the judgment and understand it.
Sir, there is a question that who are the authorities to whom identity can be revealed? I think this is already you have explained in
Identity
your
can
presentation.
only be revealed, I already told you, can only be revealed to the concerned government officials, either the police, if they require that, or the court, or any other labs. But we do that only in sealed covers. We do not write any document. Every document that we deal with in the hospital goes under the heading of confidential, and it goes only in sealed covers from one department to another department too.
There is a question from Dr.
Sir,
VD
this
Gupta,
is
sir,
Dr.
that,
Manish Nigam.
Anji sir.
Sorry, sir.
सर एक लास्ट क्वेश्चन चैट बॉक्स में से सर लास्ट क्वेश्चन ले लेता हूँ. There is a question from Dr. VD Gupta, sir, that teenage minors do they have the enough mental maturity to decide about her child in the womb?
Teenage
Do
mothers.
teenage
Teenage
minors
means
have
less
the
than
enough?
18.
Hello, just a
Yes,
minute.
sir.
I clear my question or my statement.
Yes, sir.
Am I audible?
Yes, sir. You are audible, sir.
Yes, sir.
In one of the answers, you have said that in case of minor with baby in her womb and she wants to carry it on, while the parents say that baby can be terminated, I have to say that teenage women, say 17 and a half, or we can say 17 years and 364 days. Technically, she falls in the minor group, but she is mentally mature enough to decide about whether to carry on the pregnancy or not and to give the birth. And probably there are certain judgments also.
Yes, sir.
on these-
Recently, there was one judgment, but that was from a high court, not from the Supreme Court.
So in so many cases of say sexual offences, even Supreme Courts have given acquittal to accused in such cases that the sexual intercourse was consensual, and we just don't go by the number of years or number of days she was minor and not completed 18 years. Does that not apply when it comes to carry on the pregnancy?
Yes, sir. You are correct, sir. But the act is very particular. Act says, POCSO Act says that if the girl is less than 18, even by one day, it comes under POCSO. And we have to deal with only as POCSO. Otherwise, she goes to the court and gets whatever judgment she wants from the court.
Okay.
We cannot do anything on our own.
Okay, thank you.
Sir. Okay, sir. Yes, Dr. Manish Nigam, sir.
Sir, just a query, sir. Sorry, sir. You just gave an example of a patient coming to some pulmonary medicine,
Yes, sir.
and actually, what I am understanding that she must have come for some other ailment, right?
Yeah, she came to pulmonary medicine because of some
pulmonary
breathing
medicine.
problem.
Now, so I'm actually not aware of that, and I have not gone through that. The judgment that you are talking about. But just a query: are we supposed to inform such cases which
Yes,
are not
sir.
coming for
Yes, sir,
or
it is
for any such?
mandated. Sir, यदि
Means
आपने
are
inform
we
नहीं किया
investigating
तो
officer of the same means we have to look
sir,
into?
POCSO में ये it is very clear in POCSO कि यदि आप government institute हो, private institute हो, even a normal citizen of the country, and if you have any information regarding any sexual assault survivor who is a minor, then it is mandated by the act to inform. Section 19 of the POXO Act mandates that you inform. Otherwise, there is a prison term of 6 months to 1 year.
No, that is fine, sir. Means
Ah.
if we come across this sort of case, that we are confirm about that. But here she's coming for just some treatment
Sir,
and just
वो-
looking into that baby.
उसने अपना एज बताया 17 साल की है, उसके पास 1 साल का बच्चा है, यानी कि 16 साल पे शी वॉज प्रेग्नेंट. पॉक्सो के अंदर आ गया एंड पॉक्सो मैंडेट्स दैट यू इन्फॉर्म.
So probably, sir, mean to say
Sir.
that our role is to inform the police. I think subsequently it's duty of the
Yes,
police to
our
decide
role is
whether
just
they
to inform
need to
police on
proceed
Yeah,
with the
whether
case or just
whatever they
close it.
do, that is none of our business.
Yeah.
Our business is
That
we
is
have to
fine.
inform the police.
But I have never means come across such
So-
cases.
Sir,
because
आप
the
sir
patient-
please एक बार
that is
दोबारा
fine
आप एक
that
बार
also
देखिए.
says this. Also, you are right. But practically, since patient is coming for some other treatment,
Whatever.
and we are being vigilant
Whatever,
about.
sir.
Okay,
You are
okay,
citizen
Manish
of
sir.
you are citizen
that
of this
was
country.
very
That's
well.
it.
Sir,
So
one
if
more
there is-
question.
Pramod ji, last question from your end.
Sir, one situation was there. A minor came for the termination of the pregnancy under the POXO Act. But initially, when she came for the termination of the pregnancy with her parents, they terminated, but not ready to complain under the POXO Act after informing the police. And say, suppose 15 days or 1 month after the police came with the requisition letter that this girl was examined in your hospital and she was pregnant, and now give us that the some products of conception after 15 days or 1 month. So my question is, up to how many days? Gynae people ask us, up to how
Okay.
many days we have to preserve that products of conception, and the complaint was lodged after 1 month or 2 months. Initially, there was no complaint.
Now, see, the girl has come to your hospital only for MTP, right?
Yes, sir. Yes, sir.
So
But she
again,
is minor.
again,
She is
as
minor.
per the- yeah, I have understood your question. My answer is, as per the judgment of the Honorable Supreme Court, when a minor girl comes to you for MTP along with her parents, then you have to ask her whether you can reveal her identity to the police or not.
Okay.
When the girl and her parents say no, then you cannot reveal her identity. So you just
No,
tell
sir. It is
Huh?
no. It is not about her identity. We do not reveal her
when
identity.
you do not reveal her identity to the
Yeah.
police, then how can you give products of conception to the police?
Yes.
So
No,
I
no,
think
that is the
Pramod ji,
problem, sir. The gynae people
think-
terminated that pregnancy. Gynae people terminated that pregnancy, and they are asking us, sir, up to how many days we have to
See,
keep that products of
if
conception?
it is
Because one case was there.
Sir, if it is a case of medico-legal examination of a sexual assault victim,
Yes.
not
yes.
a case of MTP only. Only in cases of medico-legal examination, you can preserve the products of conception up till a particular time, till the police comes. But if she has come only for MTP, then there is no need for preserving the contents of her conception, because you are not
Yes, sir.
duty bound to reveal her identity.
okay,
No,
okay,
sir. I am
Pramod ji,
not
ठीक
asking
है.
about the identity.
Pramod ji,
Sir,
Pramod
आप
ji,
एक बार ना,
ठीक है,
Dr.
ठीक.
Sunil, please read the
Yes, sir.
please read the judgment first.
Okay,
Okay.
sir. Okay.
So
Then
I
we can
think-
I'm
cover.
not talking about the identity
fine, it's
labeling,
fine.
sir. I am
Okay,
asking.
done.
Yes,
You can,
please read the
step-
judgment first. The judgment is clear about this.
So please
Okay.
read the judgment and then you can discuss with sir separately. It's absolutely fine. Okay. So thank you very much, sir. now we come to the end of this session, and very well presented, sir. On this auspicious day, Teachers Day, pe, we have you as an eminent teacher. You guided us about the maintaining the privacy and confidentiality in sexual assault cases, and you have given some example based upon your work experience. So thank you, sir, and thank you everyone for this third online session on this of this national FMT group. And happy Teachers Day. Thank you.
Thank you, everyone, for giving me this opportunity. And if you have any queries, you have my personal WhatsApp, my personal phone. You can talk to me there. Thank you. And with your permission,
Thank you,
Dr. Sanjay, I am leaving this.
Thank you, sir. Thank you. Thank you so
Okay.
much.
Thank you, Dr. Pramod.
Thank you, sir.
As
Thank
usual,
you.
you are a fantastic host, boss.
Thank you, sir. So I am
Thank you,
ending the meeting.
Pramod.